order. And we are so happy to have everyone joining us today. Again, this will be a recorded webinar that will be available and hosted on the Forum for Equality's website. And while there are lawyers talking today, the information provided on this webinar is for general information purposes only and does not constitute legal advice. No attorney-client relationship is formed by attending or viewing this webinar. You should not act or refrain from acting based on any information found here without first consulting a licensed attorney in your jurisdiction. Also, if you are not speaking, please remain on mute. If you are not speaking, please turn your video off. And with that, I'm going to turn it over to Scott Roos for a brief word of welcome from the Forum for Equality.
Hi, my name is Scott Roos. I'm the chair of the Forum for Equality Foundation. And we have been around since 1989, educating folks in Louisiana and advocating for rights. And that's just a quick summary. And we'll hand it over to Will.
Awesome. Thank you so much, Scott. I'm actually going to introduce Will really quickly. So Will is the director of the Juror Project here in New Orleans and is a professor at Loyola University New Orleans College of Law. His work is grounded in a simple truth: exclusion is not accidental. As a former public defender in New Orleans, he represented people forced to stand trial in courtrooms designed to convict them. He later served as executive director of the Vera Institute of Justice in Louisiana, where he advanced efforts to eliminate money bail, reduce jail populations, and shift power toward communities. Through public education, legal scholarship, and grassroots organizing, Will challenges the myths of fairness that surround the jury system. He exposes how civic participation has been weaponized to protect institutions rather than people. His work did not ask for faith in the system, it calls for clear vision. And we are so happy that he is here today to share not only his expertise, but his vision with the Forum for Equality Foundation. Thank you, Will.
Thank you so much, Jess. I appreciate that introduction. And hello to everyone. I want you to imagine that you're driving down I-10. And in the rearview mirror, you see a police vehicle with their flashing lights behind you. You do what you're supposed to do. You pull over. And as the officer walks up to your window, you roll the window down, and that officer begins to ask you questions. You're then ordered to get out of your car, and you're asked to come to the trunk of your vehicle, and the officer wants to look inside of your vehicle, and you don't know whether or not you should grant the officer permission to search your car. In this garden variety traffic stop, what we have are a lot of constitutional amendments that get triggered and activated to help govern this scenario, to ensure that your constitutional rights are being properly applied. But in order for them to be properly applied, you need to be made aware of them. So what I will be talking about today is primarily how our Fourth Amendment protection against unlawful searches and seizures, as well as Fifth Amendment right against self-incrimination, can apply to a scenario when you are interacting with the police. I'm going to share my screen. I'm going to go through a few slides. I do have a couple of videos to kind of help contextualize some of the things that we're talking about. And I welcome any questions that you have. You can put them in the chat box, or if you want to come off of mute and share your question, you're more than welcome to do that as well. Great. So let's get started. We are trying to know our rights. The Constitution was codified for a very particular reason, so that we know the protections that we have as it relates to our interaction with the government. So this is our Fourth Amendment, and the Fourth Amendment is one of the 10 amendments that are typically described as the Bill of Rights. The Bill of Rights is usually including the first 10 amendments. And generally speaking, when we're talking about our criminal legal system, we usually are focusing on the Fourth Amendment, the Fifth Amendment, and the Sixth Amendment. For this evening's conversation, we'll primarily be looking at the Fourth Amendment. Now, when we read this text, the main takeaway is that we as people have a right to privacy in the general sense, meaning that we have a right to privacy in our persons. So that includes, the clothes that we wear and the pockets that it contains, but It also includes our DNA evidence, right? We are secure in our homes. We are secure in the papers and the effects that we have against unreasonable searches and seizures. So what the Fourth Amendment provides for us is that when the government is attempting to intrude into any of these areas, right, into your body, into your pockets, into your home, they have to have a warrant. Now, there are some exceptions. There are actually a lot of exceptions to the warrant requirement, but we'll save those for another conversation. The main thing that I want you to know is that the Fourth Amendment protects people from unreasonable searches and seizures. So what that means is that if the government wants to, in fact, to conduct a search or a seizure, they have to have a warrant or some type of warrant exception. Who does the Fourth Amendment apply to? It applies to government actors. And this is generally the design of our Constitution. These are protections that we have from the government. And so when we think about a government actor, we're particularly talking about law enforcement for the most part. Now, there are some other scenarios where a government actor could be characterized to have a protection against the Fourth Amendment. But for this evening's conversation, we're largely talking about law enforcement having an inability to conduct searches or seizures when they do not have a warrant. So what is a search? There are two different ways to understand what a search is, and they come from what's called case law. So when cases are decided in front of the United States Supreme Court, the Supreme Court is usually articulating some form of a rule that is rooted in the Constitution, and they create these cases, and we refer to those cases as kind of case law as it applies to different issues. So with the Fourth Amendment, we know that a search is essentially when the government intrudes into a constitutionally protected area. So what could be considered a constitutionally protected area? Well, many of us are calling in or tuning in from our homes. I would say that the home is probably one of the strongest constitutionally protected areas. So if the government wants to come into our home, they're going to most likely need a warrant. So when we're thinking about a search, the general framework I want you to use is when the government or law enforcement is intruding into a constitutionally protected area without a warrant. Now, it's not just the physical inside of our home that is protected by the Constitution. There's this legal word called curtilage, which is really just kind of that immediate area around your home that is also protected. So if you have a fence around your home, that's going to kind of create a very easily identifiable curtilage. So the officers can't just hop your fence and begin searching around your yard. In that area immediately around your home, it is as constitutionally protected as the inside of your home. So now I want to give you a scenario. Let's say an officer is walking down the street and he sees that you have a picket fence around your home. And on your porch, he sees that you are growing marijuana plants. And based on this officer's training and experience, he recognizes the color of this plant and he recognizes the shape of the plant. And he knows that in, let's say we're in a state, well, it's illegal in Louisiana. So they see these weed plants growing on your porch. They know that that is a crime. They cannot hop your fence and seize that weed without a warrant. Now, this is something called the plain view doctrine, which basically requires an officer to have lawful access to the thing that they might want to seize, and they have to be in a lawful position to be able to view that item in the first place. So if we're thinking about the scenario, officers walking down the street, they see some weed plants growing on a person's porch, but that porch is behind a fence that surrounds the entire home. What the officer can do is take that information. He can call it in and call into his partner and say, hey, I'm at 7200 St. Charles, and I see a bunch of weed growing on a porch. I need you to file for a warrant down at the magistrate court. So the officer would have to wait to be able to come onto your property to kind of go past that fence to seize that weed, which is being obtained illegally. Because if the officer were to hop the fence, that would be a search because the officer is intruding into a constitutionally protected area without a warrant. Okay. Within the framework of, I'm sorry, I didn't define a seizure. So a search, general definition I want you to use is when the government is intruding into a constitutionally protected area. The Fourth Amendment protects us from unconstitutional searches and seizures. So a search, again, intrusion into a constitutionally protected area. A seizure is applied in two contexts. One is when the government or law enforcement is seizing your physical property. So they are seizing things inside of your home. They are seizing things from your vehicle, right? They are seizing documents from your office. When we think about a seizure of property, the general definition I want you to use is when there is an interference in your possessory rights, meaning you can't use that item the way that you normally could use it. You don't have access to that item. So the government is taking your property into possession, into their possession. They are interfering with your right to possess that item. So let's say I have a laptop, right? I bought the laptop, I've been using it, and they want to investigate me for, let's say, wire fraud. Let's say I'm doing some type of illegal gambling or something like that. If they come with a search warrant to my home for my laptop, that gives them the authority to take my laptop. That is a seizure. They have taken my laptop. They have interfered with my possessory interests. Seizure is a term that also applies to people. So if an officer seizes a person, very generally speaking, it is when you do not have the ability to leave. So sometimes you might hear people say, well, ask the officer if you're free to leave, or ask the officer if you are being detained, right? If you cannot leave, if a reasonable person would not believe that they could just get up and walk away, you are seized, right? And there are different ways in which people can be seized. For the Fourth Amendment context, we're largely requiring a threshold of probable cause. And probable cause is a legal term. Many of you have probably heard of it before. I'll give you the legal definition. Probable cause to seize somebody is essentially when we're talking about a person being arrested. And the definition is a fair probability or reasonable likelihood that a crime has been committed and the person who is being arrested is in fact the person who committed that crime. So very generally speaking, the Fourth Amendment protects us from law enforcement searching or seizing our property or our persons or searching our homes without a warrant. There is a case that has contextualized a type of stop that sometimes officers conduct. There's a case called Terry versus Ohio. And I know I have a lot of text on the screen, but I'll break it down for you. This Supreme Court case created this case law, right? This guiding framework around when an officer can stop somebody and sometimes when they can pat them down, when they can frisk them. So I want to just tell you some factual backdrop about this case, Terry versus Ohio. There's an officer who is like a patrolman, and he's walking on his regular beat. And this takes place in Ohio. And he sees a couple of guys walking back and forth in front of a store. They kind of look in the store and then they come back. Right, and then they talk a little bit, and then they go and they look in the store and they come back and they talk a little bit. And this seems suspicious to the officer. So he goes up to them and he ultimately stops them and he pats them down. And when he pats them down, some guns are revealed from these individuals and they get arrested. What this case provides is something called a Terry stop and a Terry frisk. Now, the threshold for an officer to conduct a Terry stop is this first bullet point. They have to have reasonable and articulable suspicion that a person has committed, is committing, or is about to commit a crime. So let's remember the facts about this Terry versus Ohio case. The officer is looking at these guys kind of walking back and forth, looking in this store, kind of quote unquote casing the joint, right? And he, in that moment, as he's looking at these guys, thinks that they are about to commit the crime of robbing that store. So if an officer can articulate why they have this suspicion, that's, contextualized why it's a reasonable suspicion, they can stop that person. Now, the other component is a frisk. And a frisk is just a pat down on the outer garments of your clothing, essentially. The frisk is purely supposed to support officer safety, then also safety for people who might be in the area. Now, if an officer pats me down and they feel a square object in my pocket, they cannot take that square object out unless its incriminating nature is immediately apparent. Now, that's a bunch of legal speak. What I'm trying to say is they can't go into my pockets unless they know it's a weapon that I'm carrying, or based on what the piece feels like or what the item feels like, if they know it's drugs or some other form of paraphernalia, they can take it out. So if the officer is patting me down and they feel what seems like a gun in my pocket, they can take that out. In order for a Terry stop and frisk to occur, both components have to be satisfied. Both the stop, which requires reasonable and articulable suspicion that a crime has been committed, is being committed, or is about to be committed, right? That justifies the stop. The frisk is a separate justification, and the officer has to have reasonable and articulable suspicion that the person is armed and or dangerous. So if you are walking down the street and an officer approaches you and they start asking you questions, you don't have to answer their questions. You have a right to remain silent at all times. Now, if you answer their questions, they could use some of that information to stop you and keep you from walking away. But an officer has every right to just come up to whomever they want and start asking them questions. And just in the same way that you as a citizen or as a person in this country have every right to just walk away. Now, if you are detained or if you are seized, then obviously you can't walk away. This interaction with the police lends itself to our understanding of the Fifth Amendment, which is probably the amendment a lot of people are familiar with, right? This is the amendment that gives people the right not to tell on themselves, right? It's described as the right against self-incrimination. And what self-incrimination basically means is you don't have to be the source of information in terms of the officers trying to determine whether or not you have committed a crime. So you have this right to remain silent, which a lot of us are familiar with. I want to play a quick clip that introduces us in a comedic way, like what these Miranda rights are, and I'll make sure that we understand them in their totality after this clip. Uh-oh. Of course, my sound's not working, it seems like.
The department was forced to drop the charges because
There we
Now you can save on.
go. So, um, the framework of the Miranda warnings, right? This comes from a case called Miranda versus Arizona. And we all know these rights because we've heard them a lot on TV. And there's some advising that you get from the police officer. And the reason why the Miranda warnings are provided are specifically when the officer wants to use a statement. They want to ask you questions and they want to be able to use those answers as part of their. So as you all are familiar with, the Miranda rights say that you have the right to remain silent. Anything you say can and will be used against you. You have a right to an attorney during questioning. And if you cannot afford an attorney, one will be provided to you. So, this is very generally your garden variety of what a Miranda warning is going to look like. Now, when do you need to be Mirandized, right? You have to be in custody and you have to be subjected to interrogation. And these are two terms that we have to know. So you are in custody, very similar when you're not free to leave, right? So if you're in handcuffs, right, you're probably going to be in custody. And I'm going to show a little video in a second that explains this. So you have to have both of these things. So custody is when a reasonable person, is not going to feel free to leave. Interrogation is defined as when an officer is asking you questions that they should have a reasonable likelihood to know that it's going to elicit some type of incriminating answer. So if they just say, "What's your name?" right, that's not interrogation. But if they say, "Where were you on the evening of March 17th?" right, and if you say, "I was at the corner of Napoleon and wherever," and that's where a robbery took place, right, that could be incriminating information. So when you're thinking about when does Miranda apply, you got to have these two pieces. You have to be in custody and you have to be interrogated, meaning that the officers are asking you questions. I think the next slide I have for us is it's just a little clip demonstrating these two things coming together.
Members of the jury, you know your Miranda rights, right? You have the right to remain silent, which means shut the hell up. Anything you say can and will be used against you, which is why you should shut the hell up. You also have the right to a lawyer, and they're going to tell you to shut the hell up. And if you can't afford one will be provided for you, and they're going to tell you to shut the hell up. On June 13th, 1966, the United States Supreme Court codified these rights in a case called Miranda versus Arizona. Now, Miranda applies when you're in police custody and you're being interrogated by police. But your right to shut the hell up is 24/7. So you're asking, how do I know if I'm in custody? Well, you can simply ask the officers, are you free to leave? And if they say no, you're in custody. You wearing handcuffs? You're in custody. If you're in the back of a police car, you might be in custody. So how do you know if you're being interrogated? Well, the law says that if an officer asks you a question that they should reasonably know is probably going to get an incriminating answer out of you, that's interrogation. So you've invoked your right to your lawyer. After you've done that, the police have to stop asking you questions. Unless you, for some reason, reinitiate the conversation with them, which you're not going to do because you're going to shut the hell up. Some people are going to say, well, you're innocent. And if you invoke your Miranda, it's going to make you look guilty. No, that makes you look smart. It makes you look like you know your rights and you know how to use them. Unfortunately, there are people in our jails and our prisons who did not shut the hell up. So you invoking your rights is simply using the Constitution as it was designed. So when you're interacting with police and they start asking you the questions, what are you going to do? Let me know in the comments. Members of the jury.
Right. So that is my little spiel on Miranda, right? And just this reminder that you don't need to talk to police, right? And it's your constitutional right. And even if you're not in custody and you're not being interrogated together, right? So you can be in custody and Miranda doesn't apply because you're not being interrogated, or you can be interrogated and not be in custody, so Miranda doesn't apply. But your Fifth Amendment right to remain silent and not incriminate yourself applies during every interaction with the police. So it's always a good idea, like when you're having conversations with the police, if you want your attorney, then you just say, I want my lawyer. And when you say that, the law requires them to stop asking you questions. Miranda, right, is a case that's been, well, the case was been decided many, many years ago. But what we see today are officers regularly reading these Miranda warnings for to people when they are being arrested, and people talk to police officers anyway. And what I've seen is that since these warnings have become so commonplace, that they're kind of losing some of the effect. They were originally designed to give people insight into the right that you actually don't have to talk to the police. But I think since we've kind of developed a callous to what the warnings are actually providing, that they aren't having their intended effects. So those are the general rights we want you to be aware of from the Fourth Amendment and the Fifth Amendment. And let me just kind of do a recap. For the Fourth Amendment, it stands for this premise that we have rights to be the right to privacy, essentially. That when we are in our home, that the government and law enforcement cannot intrude into our homes without a warrant. They cannot seize us in terms of a Terry stop unless they have reasonable and articulable suspicion that you have committed, are committing, or are about to commit a crime. And then when it comes to our Fifth Amendment rights, right, the main thing that you need to know is that you do not have to talk to the police and that you have the right to remain silent. Now, know your rights trainings are really important. These conversations are really valuable. But I do not want any of you to try to win the case on the side of the road, right? We have a court of law to be able to kind of flesh those things out. Obviously, when we are interacting with law enforcement, we want it to be a safe interaction. We want everybody going home in the evening. And the thing that you can remember is try to document all the things that have happened, the things that the officers have said. You do have the ability to record that interaction with the police officers to make sure you're kind of capturing everything accurately. I do want to inform people that I think in the 2023 legislative session, it could have been a year or two off. There was a bill that I believe passed that created this 25-foot buffer between you. Let's say you are just on the sidewalk and somebody is getting arrested and you take out your phone to record it. The state legislature has created this buffer that says, in order to not interfere with the police officers interacting with the individual that they might be arresting, you got to be 25 feet away. And the idea is if you get all up in the officer's face and you're not involved in that interaction at all, you then could be arrested and detained and potentially charged with violating that kind of safe zone that they were trying to create. I have to double check that law passed, because I remember when it was going through the legislature, but I'm not sure if it actually law.
Really quickly, if I can chime in, I'm like Will's law clerk over here. I just looked it up for you. It did pass, and its state court constitutionality is currently on appeal in the Fifth Circuit, in the Louisiana State Fifth Circuit.
Got it.
They heard oral arguments last Monday.
Well, look at that. A very timely reference. I appreciate you looking that up. The tricky thing about this 25-foot barrier zone, I imagine in that case they might be arguing kind of freedom of the press, right? And that we have, like, you may not actually be a press person, but the ability to kind of record and document. But how do you prove 25 feet? I don't think people are out there with measuring tapes, right, to kind of confirm that it is in fact 25 feet. So it's interesting to hear that the law is being challenged, and I'll certainly try to keep my eye on how that case develops.
Yeah, and
so
I have to apologize. I said State Fifth Circuit. I said that because Gretna is involved in the suit, so I assumed, which you should never do, it is the Federal Fifth Circuit.
Okay, interesting. Well, thanks for that. I'd love to take some questions if folks have them about that overview of our Fourth and Fifth Amendment rights. And again, we want you all to be informed of what your rights are, but also know that there's the value of having an attorney advocate for you in court. And we don't want people trying to yell your rights at officers and saying, I have the right for this or for that. We don't want anybody kind of getting hurt during these interactions. But it's important to know what your rights are. And when you have conversations with attorneys, if you do have interactions with the police and have been charged with a crime, now you have some context to some of the officer's behavior and whether or not the way in which you remember the interaction going down was consistent with your understanding of what your rights are.
Thank you so much, Will. Are there any questions?
Sure, I have a question.
Okay.
Will, is it advisable to invoke your Fifth Amendment right to remain silent, even when you know you're innocent? And if so, under what circumstances?
Yeah, my advice is to always invoke your Fifth Amendment right. Um, there have been officers who are trained to kind of use certain strategies and tactics to get you to share information that perhaps you shouldn't be sharing. There's also, a lot of research around false confessions, and there used to be this technique called the Reed technique, which was a particular way to get people that would increase the likelihood of people um, confessing to false crimes. And a lot of us might think, well, I would never admit to something that I didn't do. Well, if you're being interrogated for 30 hours and you haven't been able to sleep and there's been all these conditions, right? Your body might just do whatever it takes to stop the conditions of interrogation that you're being subjected to. So my advice, even if you're innocent, is to always invoke your right to an attorney, is always to invoke your right to remain silent, just to ensure there isn't any possibility in which you as an innocent person could be blamed and potentially tried to be convicted for a crime that you did not commit.
So a follow-up to that, then, I've seen some social media videos, don't cringe at that, where, I've seen
I mean, I make
so-called
it.
lawyers, get pulled over for a traffic stop and they crack the window open, hand the license and registration, and basically say, I'm not willing to discuss anything with you. Is that advisable on a pedestrian everyday traffic stop?
So officers are going to sometimes respond to the energy that you're giving them. And if you are kind of just cracking your window and just sliding the paperwork, they might suspect you're either one, trying to hide something, or two, you're just trying to be a know-it-all and flex your constitutional knowledge. And they may not like that. So instead of giving you a warning, they might give you a ticket, right? So I think you kind of have to read the interaction. Now, let's say you get pulled over for tinted windows. You can roll all your windows down and you don't have to roll them back up for them to be measured, right? Because you have a right against self-incrimination. You don't have any requirement to give them the evidence to measure your tint to prove that it was violated, right? So in those videos where you see people kind of cracking the window and passing things over, you're probably going to tick the police officer off, and you may, walk away with a ticket instead of a warning, depending on what you're getting pulled over for. My advice is always interact with the police officers in a way that is respectful, but also, an invocation of your rights. And I have unfortunately seen and read about too many examples of interactions between citizens and people and police officers that did not end the way that they perhaps could have, and identifying kind of pompous behavior, both on behalf of the officer and the individual involved.
Thank you.
Yeah.
And Will, I do have a follow-up question that was submitted in the chat, and it's how do you invoke and how do you waive the Fifth Amendment?
Yeah, great question. So the Fifth Amendment has to be knowingly, intelligently, and voluntarily waived. And what the court requires is a demonstration that you have, in fact, been advised of all of your Miranda warnings, your Miranda rights. And usually officers either have that little script memorized or they'll take out a little note card and they'll read it to you. After they've read you your Miranda warnings, they will ask you something along the lines of, having heard your rights, are you willing to speak to me? Right. And if you say, yeah, I'm good, right, that could be deemed a waiver. Sometimes if you're at the police station, they will have a little card for you to sign with the warnings and the Miranda rights on that card, and you signing is going to be an indication of waiver. Now, there's also ways in which your behavior and your conduct can be interpreted as a waiver. In terms of invocation, one way to invoke your right to remain silent is literally to just remain silent. You don't say anything. You don't say, I'm remaining silent. You literally just shut the hell up. You close your mouth and you don't say anything. Um, Another way to invoke your right is you can say, I want my attorney. And you have to be very clear, like, I want my lawyer. I want my attorney. There was a Louisiana Supreme Court case that originated out of New Orleans when I was at the public defender's office. And there was a man who said, I want my lawyer, dog. And the Supreme Court said that that was not an invocation of an attorney because there's no such thing as a lawyer dog, right? Now, had the person said, I want my lawyer buddy, or I want my lawyer friend, or I want my lawyer, my guy, right? Like any little tail kind of tail end on that sentence, would it have been interpreted differently? I really just do not like that case because it doesn't recognize like the different styles and forms of communication. So the ways in which you need to invoke your right to an attorney is say, I want my attorney, period. You can't say, should I have my attorney? Would it be better if my attorney were here? Right? You just have to say, I want my lawyer. Keep it clean and keep it simple. That's how you invoke the attorney portion of your Fifth Amendment rights.
Awesome. Thank you, Will.
Yeah.
All right. I don't see any other questions that have come through on the chat. Ryan has a question.
Yes,
This
I
is
do have a
Ryan, even
question.
though he technically is under my name.
Hey,
Oh,
Ryan.
I am?
Yeah, it's weird. Just go ahead.
Oh, okay. Hey, Professor Snowden. I actually have a question that I want to tie in this topic into kind of what we do and who we represent as the Forum for Equality. So, as you probably know from a recent United States Supreme Court decision, I don't know if they rendered a full opinion on it, but it was known v. Vasquez Perdomo. And the Supreme Court said that basically language can be one of the relevant factors when forming a reasonable suspicion determination. By the way, can you hear me?
Yes.
Okay. And my question is, how concerned are you, and are you seeing any court decisions where specifically trans women are being profiled based on, their aesthetic or the time of day of the police interaction, where, there are serious Fourth Amendment concerns that goes with arrest, stops, and whatever else there might be with police interaction?
For the first part of the question, as it relates to language being one of those variables that law enforcement can cite as part of their suspicion, I think the court got it completely wrong there. And it essentially gives a pass for racial profiling, which is a problem. As it relates to the question about trans women and the increase, or if I've noticed any increase in the number of stops, or interactions. I don't have personal knowledge of increasing stops for trans women. I do know the biggest issue, at least when I was a public defender and I represented trans women, was the kind of classification of where they would be housed within the jail, right? And the potential increase of sexual assault, depending on where they were placed and the concerns around that. And typically what I would see, unfortunately, some people do is they would, falsely claim that they had suicidal thoughts so that they would get put on what's called suicide watch, which at the time was a different kind of tier and location within the jail, and you're in your own cell. And although the people wouldn't necessarily have suicidal thoughts, they were doing that as a defense mechanism because the jail was not
Protect themselves.
appropriately classifying them. You have to protect themselves. I have seen, this is just from personal experience, sex workers who were trans be treated very poorly by the court. And in terms of just like I've heard derogatory terminology used by
Judges.
members of the court, right? And just being really concerned about how their perception of that person's identity can, activate these explicit biases that they have and how that can translate into the potential punishment or
Right.
even me as the attorney advocating on behalf of that person, right? If they don't like my client, everything that I'm doing, they're going to kind of take out on me. So, as it relates to the increase in arrests and perhaps different types of treatment by law enforcement, I'm not familiar with that data, so I don't know kind of what the trends may or may not be. But as it relates to when trans people have been brought into the criminal legal system, whether that's at the jail or at the court, I do have personal experience seeing some of that disparate treatment.
Yeah. And to follow up on that, you're seeing that judges or court staff are using not just incorrect terminology, but sometimes it could be discriminatory or it comes with more than what the words are being used to convey. So what do you think, as a professor who is thinking about ways to change the courtroom, ways to change juries, how do we bring that education to judges? How do we, as leaders in the community, inform judges, court staff? What would be your recommendation on that?
Yeah, I think Court Watch has been able to bring the tool of transparency to help change, courtroom behavior, but
Mm,
also illuminate some of the things that the judges are struggling to navigate themselves. Whether it is defense attorneys being ready or prosecutors being ready or the sheriff bringing incarcerated people to the court. So that tool of just kind of having somebody in the courtroom, just watching what's going on is really interesting. If we're talking about strategy and wanting to get judges to change their behavior, I would recommend having a conversation about determining how the judges want to be measured, right? When I used to work with the Vera Institute of Justice, we use data a lot, and I would often say you can't manage what you don't measure. And before I came to the organization, there was some evaluation of the courts, and the courts really rejected the data and they rejected the analysis. And so strategically, I was thinking through, well, we want judges to be successful and we want to make sure that they're doing their jobs. Let's have them articulate the metrics with which we can evaluate them, because when we come out with a report, they can't fight the framework of the analysis if it is something that they have created. And then we create a feedback loop for them. And we think about what are the things that they think they should be measured by, and then what are the things that the community wants to measure judges by, and having that conversation could be a potential strategy to change judicial behavior. There was also a time where judges would be ranked solely on how many cases they processed on their docket. And I think that is just a very arbitrary way to measure the judges, right? Some cases are very complicated and there are a lot of issues to be litigated. So the length of that case is going to be super long, whereas other cases are very straightforward, may not be too many issues. And so we shouldn't necessarily equate a ranking of a judge with the speed with which they are processing cases. And that was a framework that the Metropolitan Crime Commission used to use a lot. I don't know if they're using it anymore, but we should be very cautious around using case processing as like the main variable in which we're measuring the efficiency of judges.
So you're saying, approach judges, say, we really want to advance in this area, but we want you to give us a framework for how to objectively or subjectively measure your progress or measure your approach to this community.
I think that's certainly part of it. And I would add, you can say we as a community have come up with these things that are really important for us to know about how you're doing your job. And you can share them with the judges and see, what are we missing in terms of evaluating, how a judge is performing their responsibilities, right? And I think building consensus around what needs to be measured helps prevent people fighting over what the data actually means on the tail end because there's been a dialogue about what the measurement actually should look like.
That's really helpful. Last question.
Yeah.
Who would you recommend on the bench, at least at criminal district court, who would be open to these type of conversations? Get in with the entire bench.
Yeah. I believe I have to check this. I don't know if Judge Tracy Flemings Davalier is still the chief judge. It may have switched to Judge Juana Lombard, but I would start with the chief judge, and that title is really just it's in name only. It doesn't have anything to do with seniority. It just kind of helps. It's the person who is tasked with kind of doing some of the administrative functions. Because ultimately what you want is consensus amongst all 12 judges, right? Because if you only have 3 judges who are committed to this evaluation framework, then it's not really having the effect that you would want it to have. And then from a political calculus perspective, if only 3 judges sign up, they might say, listen, I'm not going to participate unless all 12 participate. Well, actually, it's not even 12 anymore. It's 9. Unless all 9 sign up, because that data could be used against them when they're up for re-election. And from a, that political calculus lens,
Right.
they don't want to create additional ammunition of what their opposite, if they're being challenged, of what opposition might try to use against them.
Right.
So I would figure out who the chief judge is. It's either going to be Judge
Okay.
Tracy Flemings Davalier, or it may have transitioned to Judge Juana Lombard, and I would start there.
Thank you, Professor Snowden.
You got it.
And Will, thank you so very much for sharing your time and talents with us this evening.
Yeah.
Thank you again. I'm going to turn it over to Nick to read us out.
Great.
Before I do that, Will, did you want to plug the Juror Project before we close out for the evening?
Sure. I love the democratic institution of juries, and I recognize that there is so much power in that jury box, and too often we as a community don't get excited about accessing that power. And my message for you all is the next time you get a jury summons in the mail, be excited to serve. I recognize, and Nick and I were chatting about this a little earlier, that our current process of people participating in the system of trials and jury trials, it needs to be improved. There's a lot of things that have to be changed to make that user experience much more smooth. But we are talking about ensuring somebody gets a fair trial. And the way in which we can help do that is to make sure that our juries that are occupying the courtrooms where these trials are taking place accurately reflect and represent the values and demographics of the community. So I want to just make sure you all understand the importance of jury service. And the next time you serve on a jury, next time you get a jury summons, I want you to be excited about that opportunity to exercise that form of civic engagement. Thanks, Nick.
Great. What's the website for their Juror Project?
I'll put it in the chat. It's just www.thejurorproject.org. Oh, wait, is it the or just Juror Project? Shoot. Let me check.
I'll chat for a minute. You can figure it out. No worries. So,
and then Instagram is just at Juror Project.
So in addition to being a distinguished professor of law at Loyola New Orleans Law School, Will is the executive director of the Juror Project, which is an organization that educates on the importance and how to navigate the juror duty process. I encourage you to check out his website and attend one of their trainings if you get the opportunity. Finally, I just want to thank everybody for attending today. My name is Nick Poche. I, along with Jess Waltman, am a co-chair for the Education Committee for the Forum for Equality organization. As you all know, June is Pride Month, and we are trying to make a big splash during Pride Month, we being Forum for Equality. So we do have a handful of events that are coming up this month that I would like to point out. Last weekend, NOLA Black Pride was rained out, so they have rescheduled their community fest for this Saturday to coincide with the New Orleans Pride Festival. So June 13th from 1 to 5 p.m. note the location, Armstrong Park. This is a location update. The community festival will be taking place, and Forum for Equality will have a table with some member representatives there sharing what we're doing every day in the organization. Likewise, during New Orleans Pride Fest, which is in the evening, right around the corner from the Phoenix Bar in the Marigny, we'll also be hosting a table at that Pride Fest. So please stop by either, during the day, 1 to 5 at the New Orleans Black Pride Community Fest, or 5 to 10 at the New Orleans Pride Fest. Additionally, there is a Pride Resource Fair happening the day before on Friday, June 12th at the University Medical Center downtown. And finally, we will be participating in Baton Rouge Pride Fest on June 27th. So we hope that you can come out to any or all of these festivals and celebrations during Pride Month. Please, if you haven't signed up for our email list where you can be privy to additional events, programming, and announcements, you can do so at forumforequality.org.